The first case to come before the court is State of Ohio versus Stephen Sutton. Each party will have 15 minutes to present its argument. The appellant may reserve up to 5 minutes for rebuttal. Mr. Gallup, before you begin, let me know how much time you want to reserve. I'll do my best to keep track for you. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up, remain behind the podium. Do not use the names of any children or victims in your argument. And we have read your brief, and we're ready to begin when you are.
I would ask for 5 minutes, Your Honor.
All right, thank you.
May it please the court, opposing counsel Donald Gallup on behalf of defendant appellant Stephen Sutton. We're here on 3 assignments of error today. I would like to just quickly go through the first assignment of error that I apologize if the court finds this assignment of error confusing. It might be because I'm confused as to how the local rule works. It's a minor issue at best, but I thought it would be good to put in front of this court whether you find it moot or not, because I think there's more and more issues of having problems with courts not having court reporters, and then the question becomes, when does appellate representation begin, when does it end? And there's multiple cases that I've personally handled where you can't get the trial court or municipal court to appoint a court reporter. And so then the issue is, am I representing the client in municipal court? Am I in the appellate court? Am I in both? It just seems to be a bit of a mess. Maybe this case can help illuminate that. Maybe it's not the right case for that, but I put it in front of the court nevertheless. If there's no questions on that, I'd like to go to the more substantive issues 2 and 3. This case is failure to stop in an accident. Now, the police might say, well, really, it should have been an OVI. It should have been something like that, but it wasn't. It wasn't charged as an OVI. There's no alcohol offense before the court, and so that goes to assignment of error 3. You have testimony about the officer went to Mr. Sutton's home. He smelled alcohol. There's an objection. It's overruled. There's discussion about alcohol. Is that prejudicial? Does Rule of Evidence 403 prohibit that? I say that it does. And then we go into this different standard of review where Ohio Rules of Evidence, it's a mandatory rule, but it's an abuse of discretion if you don't follow the mandatory rule. You can explain that to me. It doesn't make any sense. It's a mandatory rule, but there's an abuse of discretion if you don't follow the mandatory rule. Seems like a mess. The substance of assignment of error 2, I put right in the brief. Case law doesn't work well for us on assignment of error 2. The statute seems to be written as such that if there's an accident and the 2 people are neighbors and one of the person responsible for the accident leaves the scene, calls the police officer, hey, it's Sheriff Taylor, we know Andy Taylor, we all know him, you're guilty of the offense. That seems to be the plain language of the statute. It seems to be an absurd result. Like the facts in this case, the person who was hit, that Mr. Sutton hit, he had his information. He had photographs of his car. He had photographs of his license plate. The officer testified. We got at least 4 phone calls in from both sides. Everyone has everybody's information. Mr. Sutton gets tired of waiting for whatever reason. He goes home. He's guilty of the offense. This court could say, well, that's the plain language of the statute, but it seems to be an absurd result that the 2 people in an accident, everyone knows who everybody is, everyone exchanges information, everyone calls the police, I'm tired, I have to go home, I have to go to the bathroom, you're guilty of the offense. If that's, it seems like an absurd.
Would it also be an absurd result that somebody could basically destroy evidence or create new evidence or whatever? I understand this is not charged, and I know that's what the prosecution is alluding to, that this is probably somebody that was drinking. But nonetheless, if you allow people just to leave the scene of an accident, where do we stop? And he does go home and calls in and says, I'm going to start drinking.
Well, that's in the record. It is. And you can certainly say the facts of this case, you could say Mr. Sutton made some decisions. Why did he do that? He certainly made some mistakes in this incident, not just hitting someone's car, which he took a minor misdemeanor. But as far as leaving the scene of the accident, the point of the statute seems to be that we know who is involved in the accident. We have everyone's identification. We have everyone's contact information. The police are contacted. All of that happened. The purpose of the statute seems to have been satisfied here, even if the plain language of the statute has been violated. so to speak. I mean, what the statute appears to be trying to prevent, someone hits your car, takes off, I don't know who hit me, I don't know where they are, I don't know if they have insurance, I'm never going to get recovery or restitution or whatever. None of those are issues at play here. Everyone knew who Mr. Sutton was. He called the police. Everyone called the police. Everyone knew who he was. They had photographs of the car, photographs of the license plate. If you left immediately from the scene, hey, I'd like to take a picture of the damage to your car. No, I'm leaving. Well, certainly that would be, you could say, you're destroying evidence or hiding, concealing what happened. But then the other question is, how long do you wait? I mean, Mr. Sutton gets out of his car. Again, maybe not a good decision on his part. There's testimony that he's yelling and screaming, you hit me, no, I hit you, this kind of stuff that probably happens a lot in auto accidents. Their tempers are raised and people are screaming. Mr. Sutton testified, perhaps the jury didn't believe him, but Mr. Sutton testified, well, I was afraid that the other driver was going to assault me. That's what his testimony was. You could say, well, that's not credible. The jury didn't believe it, but that was his testimony. You know, I was worried there was going to be a fight. I called the police. He has my contact info. I'm going home. You know, you could say, again, not the smart move for him to do, but you could see a lot of people making the same type of decision. If it was a fact of this case that there was evidence that was thrown out, or there were bottles of whiskey in his car that he was taken to the dumpster or something like that, that would be one thing. But none of that is in the record. There's no alcohol offense alleged in the record. There was no testimony that Mr. Sutton was drinking prior to the accident. There was no testimony that they thought he was drinking during the accident. But yet, you know, the police officer pretty much says, well, I think he was guilty of an OVI. Well, we all have thoughts, but it's not probative. It violates Ohio Rule of Evidence 403, and that's really all you have in this situation. I think the question is, even if the statute is, the plain language is violated, I mean, are there any other exceptions that are carved out? I mean, you know, often is the case, police will say, look, you know, we're going to, there's bad weather, there's ice, there's a lot of things going on. We're not going to be able to come out for an hour. Well, I can't wait for an hour. I'm going to leave. I've given the guy my information. I've given him my insurance. I've given him my driver's license. I'm leaving. Well, you might be guilty.
Hear that?
Well, I don't know if insurance, I don't remember if FRA is shown.
What about just name and that information?
Giving
it to the other driver.
I believe it was given to the other driver, and I think it was given to the police, which is how the police came right to his home. I don't think the police had to do a search for him. I think there were phone calls going on both sides.
It was given to the police when he made the call to the police.
Right.
What was it exchanged with the other driver at the scene?
Your Honor, I'm not sure. I'm not sure. I know that the other driver had taken photos of his car, and I believe taken photos of his license plate. And Mr. Sutton, I think, was walking around on his, I think he was calling the police while he was walking around the car. But yeah, whether he actually gave his full name to the other driver, I don't want to say that and be mistaken.
Transcript.
But if there's no further questions, I'd reserve the balance.
No,
Okay, thank you.
Good morning. May it please the court, my name is Megan Philbin. I represent the appellee of the state of Ohio in this appeal today. The first assignment of error from the appellant in this case addressed Medina Municipal Court's Local Rule 6A. And that local rule very basically requires attorneys to file a notice of appearance in the court before they start filing motions or anything in the court. So they just have to identify themselves. The procedural history here is that appellate counsel did file into the Medina Municipal Court, and the court had, I believe these judgment entries are a part of the record, requested that appellant counsel identify themselves through a notice of appearance. Appellant counsel was still able to perfect this appeal, still able to get the transcript in these proceedings, even though the court was saying, please file a notice of appearance, he was still able to do all of those things. So the main point of the appellee, the state of Ohio, is that this issue is moot because the appellant was not limited in any way. So Mr. Sutton's counsel was not limited in any way. He was still able to do everything in order to get us here today. The second issue that was raised by Mr. Sutton dealt with the sufficiency of evidence. So Mr. Sutton, through counsel, had raised a criminal rule 29 motion at the end of the state's case, which was denied by the court. And the specific statute that we're talking about here is, we call it colloquially the hit-skip statute, or leaving the scene of an accident. And that statute, excuse me, requires the parties involved in the accident on a public roadway to exchange their information. And that information is their identification, so who they are, also their, I believe their license number they have to exchange, and in this particular case, the accident had occurred, the parties had both stopped their vehicles, and there was a brief exchange. There was maybe 30 seconds to a minute what the parties describe of an exchange between the two of them, and I believe one side was saying, you caused it, the other side was saying, I didn't cause it, and
Is that a verbal exchange or an exchange of information?
just a verbal exchange. The two parties from both sides, so Mr. Sutton did testify, and the victim in this case also testified and said there was a very brief exchange, and the content of that conversation was blaming the other person. And that was it. There was no, hi, my name is Mr. Stephen Sutton, my name is the victim in this case. There was no exchange of that information, no exchange of insurance information, no exchange of like a cell phone number, anything like that. There was absolutely no exchange between the two parties at the scene of the incident. And that's what the statute requires. And the important thing is when the appellant is saying, we get that information ultimately. Well, it's easy to look at this after the fact and say, well, what information was overall exchanged by everyone involved? But that's not what the statute specifically requires. It requires the parties to stay at the scene of the incident, exchange the requisite information with the parties at the scene. And so that includes our victim here. That includes a police officer if the police do get involved. And here our police did get involved. And Mr. Sutton did not give his information to the other driver, and he did not give his information to the police at the scene of the incident. Mr. Sutton does claim that he had some fear at the time, and that's why he had left. But there were many options. He could have sat in his car and waited and locked the car. He could have gone into one of the establishments. This was right by the public defender's office. It was right by Miss Molly's tea house. There's a bank right there. There are a lot of options, and we do get testimony from both parties that he was going in and out of these establishments and then decides to just leave the scene instead of staying for the police. And another important fact as well is Mr. Sutton alleges that he makes a phone call, which we do have a record of one phone call, and he admits that was the only phone call that he made. And the dispatcher who was speaking with him tells him, well, the police are now there on scene. You can go back there. It's now safe. You can go back to the scene. If you were so afraid and that's why you were leaving. But then he decides to be at his home, continue on his way to his home. He alleges that that call was made at the time he was at the scene, but that wasn't believable for how long that he had to travel to his home. And so in part of the 911 call, or the non-emergency, I'm sorry, he made a call to the non-emergency line that was recorded. It says initially he wasn't at home, but then at some point he was home, and it was not believable that he had made that initial phone call while he was at the scene of the incident to report that. So it's the state's position, specifically on that assignment of error 2, that we had presented sufficient evidence in our case in chief that Mr. Sutton did not exchange the statutorily required information to the parties he was supposed to. So most importantly to the victim in this case, I believe it's important that victims in these incidents, both sides in these incidents, get the information of the other person just in case they do have to file an insurance claim. That's the point of these statutes, is to protect the parties involved. And so that information wasn't exchanged, and that's why Mr. Sutton was charged with this offense and convicted of this offense. The third assignment of error deals with any testimony regarding alcohol consumption by Mr. Sutton. And I think it's important to note that in the state's case, what the state presented during trial was that Officer Moran, who did respond to Mr. Sutton's home after the incident, he only testified he noted an odor of alcoholic beverage. And the other evidence the state had presented during its case in chief was a 911 call that the defendant had made. And those are the only two things that the state had presented in their side of the case. That second fact, the 911 call, that was jointly stipulated by the parties as evidence in this case. And so that leaves the only piece of evidence that the state presented that was in dispute was an officer saying that he noted an odor of alcoholic beverage on Mr. Sutton's breath when he responded to the home. During the defendant's side of the case, there was some additional questioning about alcohol. And any further discussion on this topic of alcohol either came from his own counsel, from Mr. Sutton's trial counsel, or it came from questioning on the 911 call itself. And so the state did not put forth this theory that he was avoiding this OVI that came up during the defendant's case. It did not come up during the state's position, the state's case. That wasn't the argument the state was making from the onset of this. And so that came up later in the case. So it's the state's position that Mr. Sutton was able to thoroughly discuss these issues, because we could see this before the trial even started, that there would be a discussion of alcohol. There was a motion in limine filed by trial counsel, excuse me, Mr. Sutton's trial counsel in this case, and it was trying to limit any discussion of this alcohol consumption, and the court denied the motion in limine. We did have discussion, and we had discussion in chambers about the motion in limine, but also we did have some discussion on the record, I believe, as well, to let out what the issues would be and discuss what was appropriate to come in and what not to come in. So it's the state's position that Mr. Sutton had ample opportunity to address these problems during the trial and raise objections about these issues, and he did raise objections about the issue of discussing anything about alcohol consumption. And it's the state's position that there was not abuse of discretion in this particular case in allowing this discussion, especially since the parties had jointly stipulated to the admission of the 911 call, where he says that he's consuming alcohol on the 911 call and is relaying that to the dispatcher.
Did the other side stipulate to the authenticity of that call, or its admission into evidence?
Both, I believe, Your Honor.
Okay.
So given the state's position, given the state's argument, I would ask that the court deny each of the appellant's assignments of error and affirm the trial court's decision here today. Thank you.
Thank you. Mr. Gallagher, you have your full 5 minutes.
Oh,
for
thank
rebuttal.
you. Judge Callahan, your issue of the stipulation, was it authenticity or admissibility? Appellee says it's both. I was trying to find that. I can't find it, but in Appellee's brief, they reference State's Exhibit 4. I wish I could waive State's Exhibit 4 and say, look what the stipulation says. I can't do that. But I can say this. Obviously, there was an eliminating motion to preclude all alcohol testimony. And then when it first came up during testimony, that motion to eliminate was preserved through an objection. Trial court overrules it, says, no, that's fine. And then you say, well, look, defense counsel gets up on cross-examination, talks about alcohol. Well, what else can you do? You file a motion to eliminate. That was, preliminarily denied. You make an objection to any testimony about alcohol. That objection is overruled. So now the jury's sitting right here. You have to bring it up on cross-examination. So I don't think we could say that was trial counsel error for talking about it in cross-examination when the eliminate motion was denied and the first objection was denied. As to the 911 call that has a mention of alcohol in it, I can't tell you what that stipulation is, but I'm sure the court will find State's Exhibit 4 and clarify it for us. The only other thing I can say about assignment of error 2, which is the crux of the whole case, is that we acknowledge there's case law against us. There's case law of the 1st District, I think the 3rd District, where, you know, I think one is State versus West I cite, and everyone says, yeah, I know the guy who hit me, he knows me, everybody knows everybody, still gets convicted of leaving the scene of an accident, which seems like, well, that's insane. But that's what the court ruled on there. And then there's State versus Bryant, which I believe is the 1st District case, where everybody exchanged everyone's information, everyone's happy, but the police said, well, you didn't give it to us. They get convicted of leaving the scene of an accident, which again, seems, what is the purpose in that? Everyone has the information, everyone knows what they need to know. But the statute was amended in 2016. I don't think it's been litigated that much after the 2016 amendments. But again, you know, I'd like to sit here and tell you there's all this case law saying that the statute was not violated, but you know, under the current case law, it doesn't look very good. I don't think there's an opinion out of this court on that. If there is, I didn't find it, but there is out of sister districts. Unless there's any other questions, I thank the court for its time.
Thank you. We'll take the matter under advisement, issue our written opinion in due course, which will be mailed to both sides as well as posted on our website and that of the Supreme Court. Thank you both for your arguments.